Thank you for staying with us. Now, child molestation remains one of Nigeria's most horrifying crimes, and now a bill has been passed raising the stakes, prescribing life imprisonment for anyone convicted of defiling a minor. And that leads us to discuss the imperativeness of life imprisonment for child molesters with Dr. Godtime Okafor. He is a constitutional lawyer and is also a human rights activist here in the studio with us this morning. You're welcome. Good morning.
Well, thank you very much.
Good morning.
Good morning.
I'd like to know, what do you think about this new bill for life imprisonment, and of what significance would you say that it will have on issues like this?
Thank you very much. You see, so many media have approached me about my reaction on the new bill, but I share a different sentiment altogether about the purported new bill, in the sense that we have existing laws that have taken care of child molesters and other Sexual Offences Act. We have existing laws, and these very existing laws are sufficient to curb the menace and the excesses. For example, we have the Nigerian Penal Code, and specifically Section 142, subsection 1 of the Penal Code, Laws of the Federation of Nigeria, provides that any person who have carnal knowledge of a girl under the age of 13 shall be sentenced to an imprisonment for life. It's life imprisonment. And subsection 2 of that same section 142 of the Penal Code provides for attempt for defilement. He said anybody who attempts to defile a girl under the age of 13 should be sentenced to an imprisonment for 2 years. So the punishment for attempt is 2 years, whereas the punishment for defilement proper is life imprisonment. And this section of the Penal Code is in pari material with the Criminal Code, because in Nigeria we have the Penal Code for the northern parts of Nigeria, and we have the Criminal Code for the southern part of Nigeria. So they are sufficient as far as I'm concerned. So it beats my imagination when I learned that the National Assembly is making or amending those sections of the law. They call it amendment. But in that amendment, if you go through the amendment thoroughly, you will see that they are trying to water that very section. They are trying to mitigate the punishment meant for it. Ordinarily, you don't have to mitigate the punishment. You don't have to reduce the punishment, because criminology says that the cardinal essence of enactment of laws to regulate criminal activities is to discourage perpetrators from doing the same thing. That is the essence. So when you now mitigate, it means you are encouraging them. For example, in the new bill, they said that punishment for defilement of anybody, because the only difference they put there, in the Penal Code, it said a girl. It was specific for girls and women. But in their own purported new bill, they say for anybody. So they remove a gender bias. That's the only thing I can say they achieved. But whatever be the case, the law, the court have been using it to punish any offender, whether male or female. But what they now say, the punishment for defilement of a person under the age of 10 is life imprisonment. So I don't know why they now came down from 13 years to under the age of 10 years. I don't know how they now put it that way. Under which means if you are not 10 years, you can't serve life imprisonment. That's the implication. If you are 11 years, or 12 years, or 13 years, you can't be sentenced for life imprisonment, except you are under that 10 years. In Botswana, for example, Botswana, Kenya, South Africa, Uganda, or Rwanda, their own criminal code is 12 years imprisonment. Defilement for a minor under the age of 12 is life imprisonment. Then, in Nigerian criminal code and penal code, both of them is that defilement for a girl above 13 years, between 13 years and 15 years, attracts 20 years imprisonment. 20 years is statutory provision in Nigeria. Then defilement of a girl between 16 to 18 years, between 16 and 18 is 15 years imprisonment. But in the purported new law, they did not state those areas. They said under 10 years. So my question now is, when you are above 10 years, what happens? Because I believe and I submit and strongly too, that the existing laws is sufficient. It takes appropriate care of the law when it concerns defilement and sexual offenses. So I don't see anything wonderful that the National Assembly has done.
Now, Dr. Okafor, I'd like to ask you, because when you were talking, you mentioned the criminal code, and you said that in that law, it has punishment for those from 10 and below, 13, above 13, and the likes. Now, I want to ask, why the age demarcation, and why do we have different punishments depending on the age? A minor is a minor from below 18.
Right.
So why do we have that segregation? If you're below 10, this is the punishment. If you're below 13, and it seems as the higher, the older the victim is, the lesser the punishments are. Why isn't it an all-encompassing thing, even for sexual offenders generally, regardless of the age as well?
Thank you for asking that question. You know, in animal farms, George Orwell said that all animals are equal, but some are more equal than others. All fingers are not equal. So when we come to minor, there are categories and classes of minors. A person 10 years old girl and a 13 years old girl, they are not the same. At least 13 years is senior to 10 years. The same thing with 14-year-old girl, 16 years old girl. In the criminal code, it provides that a girl under 16, no, a girl under 16 is rape. Because when we come to defilement proper, defilement should be a girl under 13, from 13 down. Then 16 years, even though the law, some laws categorize defilement, some laws say no, it's no longer defilement because some girls of 16, 17, 18 could marry. I have seen girls married at those age, even though the law did not specifically permit for that. But some families, due to arrangement, could allow their daughter to be married at tender years of 16, 17, 18. So the law now categorizes. If you now define the person at that age, if it's between 13 to 15, you should serve 20 years imprisonment. If it's between 16 and 18, it should be 15 years imprisonment. And the one thing the law does, which I like very well, is that the defense of consent is dislodged, because any offender, any perpetrator of the act, or any defaulter will always say the girl gave her consent. They always use consent as a defense. So the law dislodges consent by saying that legally these sets of categories of girls, they are legally considered to be incapable of giving consent. So the law has already dislodged that defense. There's no way you can tell a reasonable human being that a 10-year-old girl gave you consent, a 13-year-old girl gave you consent. You can't tell anybody to agree with you. So the law says, it's a presumption of the law. The presumption is that they are legally incapable of giving such acts, such consent when it comes to sexual matters. That's the law. So you cannot bring any defense. Any defense you bring must be dislodged, and that defense cannot be sustained in the law court.
All right. Now, Barrister Okafor, let's talk about the offenders and their rights. Now, from a constitutional standpoint, do you think imposing life imprisonment could actually violate any fundamental right of the offender, like right to dignity or right to fair hearing?
No, it could not, because we are talking about protection here. The essence of the law is to protect the girl child and the women generally. So there's no, if you remove that law, they will be molested everywhere. You will molest them. You can tell a small girl, go and buy me something. When the girl buys you something, maybe a 10-year-old girl who innocently want to assist you, buy something, okay, bring it inside. You bar the door and rape the person. So if the law is removed, girls will be molested here and there any second. So that law will serve as a detriment from such girl molesters, so that when they see the punishment that so and so person have been convicted and sentenced to life imprisonment, it will be a deterrent to them. So there's nothing human right in it, nothing human right at all, because the girl already have her own human right for protection. She has to be protected. The person who molested him has no human right not to serve the punishment. That's the essence of punishment. And you know, in constitutional law, section 1, subsection 1 of the 1999 Constitution of Nigeria provides for supremacy of the Constitution, supremacy of the law. It provides that this Constitution is supreme and is binding on all authorities and government. Subsection 2 of the 1999 Constitution provides that no part of Nigeria or shall be governed by a person or group of persons except in accordance with the provisions of this Constitution. Subsection 3 provides that if any other law is inconsistent with the provisions of this Constitution, the provisions of the Constitution shall prevail, and that other law shall, to the extent of its inconsistency, be void. So what applies to constitutional law applies to criminal law too. So the law is binding on everybody. Then the law is no respecter of anybody. Once you have violated the law, you have made the work of the court easier. As we categorize the ages, what the court will know is you are here, the year of the victim. If the year of the victim is 15 years, then the court knows that you are serving 20 years imprisonment, unless the court tamper justice with mercy through your plea of allocutus. If you can convince the court that you have shown remorse, or there is something, inducement, something that made you to commit a crime, then the court can mitigate the punishment. Otherwise, the court will impose maximum punishment on you. And if the girl is 15 years, the maximum punishment is 20 years. If the girl is 16, 17, or 18, the maximum punishment is 15 years. That is the law of Nigeria.
Okay. Now, you mentioned that according to these ages, that when it's below 13 or so, it's no longer defilement. It's now a case of rape, because you mentioned that at 16, 17, some families marry their daughters off at that age. Now, this question I want to ask you from a personal point of view, not legally now. Do you think that cases where minors are being married off under the age of 18, do you think it can pass off as an issue of child molestation by the people who married those children? Do you think it falls under that category?
Yes. In Nigeria, you could recollect vividly that it was an issue about some years back when a Nigerian senator, I don't know if you were conscious of that issue, it was a celebrated issue in Nigeria. A sitting senator in Nigeria married a 13-year-old Egyptian girl some years back. So there was agitation in Nigeria, even Nigerian Human Rights Commission, civil liberties organization, civil society organization, and so forth. There was agitation that a senator of the Federal Republic of Nigeria should not have married a 13-year-old an Egyptian girl. Even though if the law of Egypt permits that, the law of Nigeria does not permit it. In Nigeria, it's a defilement. I don't know the Egyptian law, whether their law permits it, but the defense of the senator, I didn't follow that matter to its logical conclusion. But the senator said in television that time that the family borrowed money from him, dollars. And when they could not pay the money, they willingly handed over the girl to him. That is the family that handed the girl over to him as an exchange for the money that owing him. Should he now leave his money and leave the girl, that he accepted that girl as a repayment for the loan. So that was the defense of the senator. So I don't know if some people went to Egypt to investigate whether it's true or not that the family handed the girl over to him. I didn't follow that matter to his logical conclusion. But
generally speaking, though, both the families that hand over their daughters and those people that accept the daughters, I'm just wondering, don't you think it can be termed it's a case of child defilement or pedophilia?
If human rights organizations, human rights activists, human rights advocates got wind of it, they will follow it up. If the media too got wind of it, they will follow it. And when it goes viral, once it goes viral, then everything will end. Because once anything is viral, the law is no respecter of anybody. The law is clear. The law has categorized it. If the girl is under this category of law we mentioned, the people, human rights activists, will not agree. Unless the girl falls into the last category. The last category is girl between above 16 to 18. That is why the law says 15 years imprisonment. If it's above 16, but not below 16. There are difference between below 16 and above between 16 and 18. Those girls, I said, that with arrangement, most of them have been married. The families have been giving them out for marriages. Families that are not enlightened, they are illiterates, they are ignorance of the law. Even though we say et ignoratio, et non excusat. which means ignorance of the law is not an excuse. But those families that give out their children at those tender age, they purport and claim that they were ignorance of the law. They don't know that such thing they have done is against the law. That have been their defense. And that is the essence of enlightenment by television like this program. Because if the media could continue relentlessly to sensitize the public on their right, then such families will know that you don't have to give out to your child at those tender age from 16 to 18 years. You should allow the girl, because one, the girl should go to school. Some men may say, when you come to my house, I will train you. And once he brings you in, he will stop your education. It will stop at that moment. So that is why the law of France has such act. And families that have the propensity and tendency to do it should learn now that they have to allow that child to reach that age of 18.
All right. Now, that brings me to ask you, what would you say are the structural failures in our society that actually enabled child molestation?
It's collapse of morality. It's collapse because Nigeria as at now is not a fertile ground to train children. Nigeria as at today is not a fertile ground to train children. I could recollect what happened in 2023 when everybody in Nigeria said that P2B won the election. And eventually, another person was declared the winner. There was a cartoon in Vanguard newspaper. That cartoon, a boy was asked to go to school. He said, no, I won't go to school. He said, why? He said, I will not go to school. I want to be a broad day robber. I want to join armed robbery so that I can rob in broad daylight and go unpunished with impunity. So you see, Nigeria, based on your question, the structure, there is structural rot. There is rot in the society. Corruption is endemic. Corruption has reached a crescendo in the society. And there is moral bankruptcy. There is moral decadence. There is decay in everything we are doing in society. Everything is turning upside down, going zigzag. And then to worsen the situation, there is hunger in the society. There is poverty in the society. So because of all this, that's the end result. The aftermath of all these things is this rape, defilement, and what have you. That's the end of all these things in the society. So if we have good government that will sit up and have the interest of the masses at heart, and then we have a good National Assembly and State House of Assembly that will make good laws for good governance of the people, because the essence of making law is for good governance of the people. That is under legislative drafting and lawmaking, is you make law that will enhance the people, the conduct of the people, the welfare of the people. But the kind of laws they churn out from the National Assembly and State Houses of Assembly, I don't blame them. I don't blame them because most of them are not lawyers. They don't know about legislative drafting. They don't know about procedure for making the law, the tenements, the norms, the rules and regulations, what you should expect to make as a law and what you should not make as a law. They don't know all these things. They don't know how powerful the law is. That even in the Bible, in John 19:21, Pontius Pilate said that what has been written has been written. In 1 Corinthians chapter 4, verse 6, Paul said, I and Apollos have transferred this, that in our good, in your own good, that in our case, you may learn the rule. Do not go beyond the things that are written. Don't go beyond beyond what is written. In Evidence Act, Section 123 of the Evidence Act, it says wherever any judgment or disposition or transaction has been reduced to documents and series of documents, there is no other evidence required except the document itself. That's agreement, and that's the law. So if the guys at the National Assembly and say houses of assembly, they know about lawmaking, the ingredients for making law, if they know about all this, then the kind of laws they will be making will be for the benefit and good governance of Nigerians.
Now, you talking about lawmaking. Another issue is implementation of these laws, because there have been cases of these offenders of, child defilement or child molestations that end up not being brought to book as should be. Like now, there is a case that is currently trending all over on social media, a girl named Ochanya who died due to an infection she got after being raped by her cousin and her uncle as well. And the suspect or the person who perpetrated that act, it has still remained unresolved. The person is still working about freely, going about his daily business. So what do you have to speak on this implementation or lack of proper implementation of these laws to the perpetrators of this act?
Thank you very much. That is exactly what I'm talking about. When we come to implementation, and also some people who commit crime, going scot-free, walking the street freely, when they're supposed to be behind bars. Now, it depends on two things. One, the nature of the law. That's number two. Two, the evidence to prosecute offenders. The law is so technical, and that's what I'm talking about, lawmaking. If you know the modus operandi for making law, you should make law in such a way that no violator can go scot-free, because there is evidential burden. It's not easy to allege. In law, every allegation, every assertion is alleged. You allege the person committed a crime. It's an allegation. And the pursuant to Section 136 of the Evidence Act, in criminal trial, it must be proved beyond reasonable doubt. There would be no shadow of doubt. There would be no ayata. There must be you must prove it beyond, not within the shadow of doubt. Unlike in civil matters, where the proof is under the preponderance of evidence, in criminal trials is beyond. And where some crimes are committed, maybe there is no eyewitness and there is no cogent, credible evidence to pin the violator. The person may capitalize on that paucity of evidence or insufficient evidence to escape punishment. He can capitalize if he has a clever lawyer. If you have a good lawyer, that's why America said that a man can commit heinous crime and go away scot-free if he has the cleverest attorney. That's what America said. If he has a good lawyer that will study the whole situation, the facts, and see any lacuna, any loophole, and capitalize on that loophole and mess up the case. Let me give an example of the case of Hope Uzodinma in Abia State. During the time, Radio Nigeria called me because I'm the radio lawyer of Radio Nigeria. I appeared in various televisions in Nigeria, both Kakaki, both channels, both Radio Nigeria, both NTA, over that matter. When Supreme Court was about to deliver their judgment, they asked me that what is my stake in this case. In that case, it's very obvious. And what I said in television and in radio is what happened. I told them that case is dicey because many people say Hope Uzodinma is a Supreme Court governor, that he bribed his way. But there was a lacuna. His case was that he got 78,000 votes only. And making Hedionha had 282,000 votes. He got 78 and he was the fourth. But there was a mistake. There was a mistake. His case was that there are 388 polling units that INEC rejected. They did not count the vote. And that he secured about 240-something thousand votes in those 388 polling units. That if it is counted, he will get up to 300 votes and pass a making head who had 282 votes. That the court shall declare that INEC shall calculate those. And the lawyer of a making head, instead of projecting a figure, instead of saying in these 388 polling units, a making head got 50,000, just 50, that if it is counted, he will have up to 330,000. He did not project any figure. He merely said, well, INEC is the umpire. They know why they cancelled it. You can't query INEC. Who told you you can't query INEC? That's what I said in Radio Nigeria. I said it in 90. I said it in Channel. Who said you can't query INEC?
So that's the same thing that plays out.
Yes, Section 315, subsection 3 of the 1999 Constitution of Nigeria said that the court can make any declaration. A court can declare that you, as a woman, you are a man henceforth, and people will regard you as a man. Court can make any declaration. I say that there is danger. Court may order INEC to compute it, include it, and this man will be the governor. And that's what played out immediately. I said it in the media. So when it comes to law, it's the technicality. The way people see it, they may say, hey, this man went through. Maybe there's no evidence because the law is that he who asserts must prove. If he asserts somebody, something happened. If this is my phone, I assert that you have stolen it. I have to prove first of all that is my phone. And I can prove it by bringing the receipt I used to purchase the phone. Then they will now ask you, where is your own receipt? If I bring the receipt I used to purchase this phone and you cannot produce your own receipt, because in my receipt, both the serial number of the phone, so many will be there. In your own forged receipt, the serial number will not be there. Then I will use my evidence to show really that you have stolen my phone. So he who asserts must prove. The onus of proof rests on me, not on you. And if I fail to prove it, then I will lose the case. So that's what happens. Sometimes you say, the court are taking bribe. They say this man free. It's not taking bribe at all. It's not taking bribe. There was a case I did in Ebonyi State just last 2 weeks before Justice Yobu in a Abakaleke High Court. In that case, I was cross-examining the IPO. It's a murder case. He said that the accused person is the person that killed the deceased. I asked him during the incident, who invited the police? The police came to the scene. Who called the police? He said it's a passerby. I said, what is the name of the passerby? He said that the police control room did not record the name. I said, will it shock you to know that the defendant is the person who called the police? He saw somebody who was at the point of death. He wanted to rescue him. And he's a member of Peace Corps, Nigeria Peace Corps. He called the police because he worked with the police. The police came, assisted him to take the person to hospital. When the person now died at the hospital, police now turned around and said, my friend, what killed this man? They started interrogating him because the person had died. So the court was shocked. That's what we mean. There's no evidence. Evidence can fall. You are alleged. You can't prove it. The court now will pronounce whether your allegation is true or your allegation is not true.
So if the victims of this molestation don't have proof, of the molestation. So are you saying that the culprit or the suspect will not be arraigned?
No,
What does that
already.
say about the justice system? Because to some people this might be injustice. Everybody is saying that this particular man, for example, elite usually in most cases go scot-free when cases like this come up.
That is why you must follow the laid down rule. There is procedure. If it's a rape matter, the first or the fireman, the first is to rush the child to hospital. There will be evidence of the blood rupture and so many other things. You have to keep those evidence, and then there will be medical report to that effect. You keep the evidence. If you have all this evidence and bring them to the court, you prove your case. But what if you don't have any evidence? What if you don't know you should take the child to hospital, take the child to police? You just keep it in your house and go to fight with the person. You have do this, you see what, you will kill me today, you will kill me. You have defied my daughter, you will kill me. Instead of following the laid down procedure, the procedure first of all, call the police. The police will take the child to hospital. The police will write their own report, hospital will write medical report. You will bring all this evidence to nail the person, and the person will go to prison. But what if you don't follow this procedure? How will you prove it?
Now, there's another thing you mentioned, still concerning, because I want to tailor it still to the victims,
Right,
like you did earlier. You made mention of if the offender shows some form of remorse of what he or she has done, that the person's term might be reduced to, if it's supposed to be 15 years, maybe reduced or something like that. Don't you also think it's still a form of injustice to the victim, who you have reduced the term of their offender just because the person has shown remorse or some form of change in one way or another?
How is it injustice to the victim? Does the victim know the punishment for the crime? The victim doesn't even know how many years. What the victim know and will be primarily concerned is that that person has been jailed. Even if it's 10 years, 5 years, as far as the person has been jailed. You see, we have changed the name now from prison to correctional center. That's the essence. The essence of the punishment is to correct the defaulter, the perpetrator, the person who have committed that crime, to reform him. It should be a sort of reformative, because if you don't reform them, the society will be so bad. So that will be the interest of the victim, not how many years, whether the person will die in the prison.
But how good are these correctional centers in actually making these people change their ways? Because most times they come out and still continue from where they stopped.
Well, it depends on the facilities available, because if there is, like abroad, if you serve abroad, they will train you in Enugu Correctional Center. I know that National Open University has a center there. GC, yes, has a center in Correctional Center Enugu. They have a center. You can stay there, write your WAEC exam, write your degree exam, write your diploma exam in the Correctional Center. So that even they learn scale now. They learn tailoring, shoemaking, and so forth. I have visited the prisons severally. I have visited even last Thursday of last week. I was at the Enugu Correctional Center with the Chief Judge of Enugu State and other justices. They went for prison visit, prison decongestion. About 83 prison inmates regained their freedom that very day. So next week, Thursday, it will be turn off on Soka prison. The Chief Judge and the other judges will go to Soka prison. I will be at Soka too. Then the upper one, it will be the turn of Oji River prison. The essence of going there is that some people who are unjustly accused may have the window of opportunity to regain their freedom. For example, we met during the prison visit of last week Thursday. We met a woman. who said that the court in Enugu State, presided over by Justice Harold Eya, had convicted her for 5 years imprisonment. And she has served out that 5 years. She is staying there now for 7 years. Then the chief judge asked him what? The woman owes somebody 6.5 million naira. The judge convicted her, they had to pay the money. I pleaded on behalf of the woman. I told the chief judge, since she has served out the prison term, let her be released. Let her now sign undertaking to be paying the money installmentally. Because if she remains in this prison, she cannot remain here to pay the money. Let her go out and hustle to pay the money. The CJ agree with me and release the woman. Discharge the woman. Go. That way you must pay that money you are owing the person. But you should not go, since you are staying for 7 years instead of 5 years. So the essence of going there is some people who have overstayed their prison terms may have the window of opportunity to get released. That's the thing.
All right. A very big thank you to you, Dr. Godstein Okafor. Thank you for joining us in the studio.
And before I go, let me also use this medium to talk about murder and accident, because this is something people don't understand. If whether you are driving a car or in any way you kill somebody, somebody died. Now, to determine whether you really killed that person or you accidentally killed a person, accidentally law, we call it manslaughter. So it is what distinguishes murder from manslaughter. To know the intention, section 24 of the Criminal Code, Laws of the Federation of Nigeria, provides that, subject to the express provisions of this code relating to negligent acts and omission, a person is not criminally responsible for an act or omission which occurs independently of the exercise of his will or an event which occurs by accident, unless the intention to cause a particular result is expressly declared to be the element of the offense constituted in whole or part by an act or omission. The motive by which it occurs is immaterial. So now, if you have killed a person, assuming you are driving, you kill somebody. Now, how do the court know whether you purposely and maliciously kill the person or you don't have the intention to kill? It's accident. Number one, you must have your driving license. If you don't have driving license and get that accident, it's murder, because ab initio you are not authorized to drive. You are driving illegally. That's why you have killed a person. You are not qualified to drive. It's that driving license that qualifies you to drive. Two, your vehicle must pass roadworthiness test. The trafficator will be there intact. It will be tested. Your brake tested. Your tires not wobbling. It should be good tires. If your vehicle passes roadworthiness test, then again, do you know the victim? That person you killed, have you from Adam met him anywhere? If you know him, it's murder. It's not accident. Do you know why it's murder? The presumption may be that you have been harboring animosity against him, and you see him that day, you use the opportunity for vendetta.
Doctor, I think this is a case that we need to revisit
and talk about specially.
Yes.
He's all right. He's all right.
Okay, thank you for joining us on Signature Morning today.
Yes, thank you so much for joining us. And Lillian, today's show, as we're wrapping up, I forgot to mention this morning that we've come to the end of the month.
Oh, right.
And I mean, it's the year is moving so fast. Tomorrow we're entering a new month, 1st November 2025. That's a great one, don't you think?
Yes, it is. It is. We're expectant.
Expectant of
the new month blessings and all the goodies from Signature Morning.
Right. Now, thank you so much for joining us this morning, and we hope that you enjoyed the conversations as much as we did. And due to public demand, as Anambra State elections are very close around the corner, we're going to be bringing an interview from our Abuja studio still on Anambra governorship elections, the challenge of vote buying. Make sure to stay tuned and keep watching. I am Uchenna Chimdi Oluoha.
And I am Lillian Wali. Enjoy.
Signature TV, news in your pocket.